Ladies and gentlemen, I thank you all for attending tonight. Our format for tonight's debate is simple. Our speakers, who have been divided into two teams, will each make their 7-minute opening statements, free from audience interference. Once their opening statements have all been made, the format opens, allowing a direct engagement with the other speakers, howsoever they wish, be it through cross-examination or rebuttal. During this period, as an audience member, you may raise an objection, but if the speaker does not heed your input, you will need to cease interference. Our speakers tonight are Robbie Ball, Benjamin Weiser, and Hannah Carmichael. Robbie studied for his LLB and then completed the bar training course at Cardiff University. Robbie is now seeking to gain pupillage and hopes to practice civil law afterwards. Robbie enjoys playing football in his spare time and is actively seeking legal experience to further his development. Benjamin completed his bachelor's in philosophy at Cardiff University and is in the process of completing his graduate diploma in law. After completing his studies, he aims to pursue a career in intellectual property law and to qualify as a solicitor advocate. He is on the weekends an avid runner and has recently completed the Cardiff Half Marathon. Hannah is in her second year, studying law at Cardiff University. She intends to practice as a barrister after completing her studies and enjoys painting and running in her free time. Now, without further ado, I hereby welcome to the front Benjamin for his opening statement dissenting from the title, "The International Law is Effective in Holding Countries Accountable for Human Rights Violations." A round of applause, please.
Hello. Good evening, members of the audience. My name is Ben, and I appear as lead counsel in this debate, objecting to the argument that international law is effective in holding countries accountable for human rights violations. I'm accompanied by my learned friend, Ms. Hannah Carmichael, who will also be objecting. I'm sure most of us here would agree with the idea of a universal recognition of human rights, and see the goal of international legal organizations such as the United Nations as a noble one, being born out of the ashes of two horrendous world wars. However, the statement that international law is effective in holding countries to account for human rights violations is deeply flawed for several reasons. Firstly, while the various bodies that comprise the UN have mechanisms designed to address human rights violations, the effectiveness of these structures is limited by political and practical challenges. The recognition of a state's sovereignty means that decisions are not binding on a member state, and they can merely ignore any judicial ruling by the International Court of Justice. For example, in 1986, the ICJ ruled against the United States in the case of Nicaragua versus United States. Yet the US simply ignored the ruling and continued its actions. This structure simply leaves it up to the goodwill of member states to comply with international law, which is often not forthcoming. There are also significant issues with the enforcement mechanisms of international law. They heavily rely on the cooperation and commitment of fellow member states to enforce their decisions and promote accountability. For instance, the UN Security Council has the power to impose sanctions, but these are often blocked by the veto power of its permanent members. A case-in-point example is the situation in Syria, where repeated vetoes by Russia and China, both well-known allies of the Assad regime, have prevented meaningful action against Syria, despite numerous documented human rights abuses. Another critical point is that the statement relies on the premise that all countries subscribe and work towards a universal shared definition of human rights. This is simply not true. It ignores cultural relativism. How can we persuade a country like Afghanistan that our conception of human rights is more morally valid than their own, which has been uniquely developed from its cultural and religious beliefs? Their view on human rights will inevitably differ hugely, and indeed does, from a country such as the UK. And this divergence makes it even more challenging to enforce a universal standard. While international law provides a framework for accountability, its effectiveness depends on the political will of powerful nations, such as permanent members of the UN Security Council. China, Russia, France, the UK, and the US often act in their own geopolitical interests. For example, Saudi Arabia has committed serious human rights violations in Yemen, including unlawful attacks on civilians and mass killings of Ethiopian immigrants. Yet despite this, powerful allies of Saudi Arabia, like the US, UK, and France, along with the other UN institutions, have failed to hold Saudi Arabia accountable. This inaction is largely due to Saudi Arabia's significant economic power and strategic alliances, which have allowed it to avoid major repercussions. The situation of the Uyghur Muslims in China starkly illustrates the limitations and arguably the ineffectiveness of international law in holding countries to account. The Uyghurs have faced significant human rights abuses, particularly in the Xinjiang province. The international community, including the United Nations, and various human rights organizations have taken steps to document these abuses. However, the UN published reports have done little in the prevention of human rights violations. There has been little effective action to hold China accountable, largely due to its significant geopolitical influence and economic power, and its ability to ignore and veto any judgments, rendering them ineffective. The Kosovo situation provides another example of the complexities and limitations of international law. In 1999, NATO launched a 78-day air raid campaign against Yugoslavia to halt the humanitarian catastrophe. The intervention, while aimed at stopping human rights abuses, was conducted without explicit UN Security Council authorization, highlighting the limitations of international law when powerful states act unilaterally. Realists argue that international relations are governed by the self-interest of states rather than adherence to moral principles. This perspective can help us understand the challenges of upholding a legal framework based entirely on a country's adherence to a moral framework, especially when it might go against their national interests. For instance, powerful nations often prioritize strategic and economic interests over human rights concerns. The realist view explains why international law struggles to enforce human rights standards consistently. For example, China and Russia often use their veto powers in UN Security Council to block actions that do not align with their interests, regardless of the human rights implications. So in conclusion, while the concept of international law and the protection of human rights is a noble one, the reality is that the current system is critically flawed. It is obstructed by issues of sovereignty, ineffective enforcement mechanisms, cultural relativism, political will, and structural inequality, and is therefore merely a body with no means to enforce its laws. Its judgments are rendering international law an inspirational ideal rather than an effective tool for justice. Thank you.
Thank you, Benjamin. I now welcome Robbie up to the stand to submit the 2 opening statements for his team.
Good evening, ladies and gentlemen. My name is Robbie Bull, and today I stand firmly in support of the resolution that international law is effective in holding countries accountable for human rights violations. Human rights violations undermine the dignity, safety, and freedom of individuals globally. International law, through its treaties, institutions, and enforcement mechanisms, provide a critical framework for addressing these abuses. Whilst challenges certainly remain, the success stories and the growing influence of international legal norms affirm its effectiveness. I will present 4 key points in support of my position. Firstly, the establishment of binding international frameworks that enforce accountability. Secondly, the success of judicial mechanisms in delivering justice. Thirdly, the impact of monitoring and reporting mechanisms. And finally, the impact of international law in shaping global norms and influencing state behaviour. I will now turn to my first argument regarding the binding current framework and how it ensures accountability. International law has established a robust system of treaties and conventions that hold states accountable for human rights violations. In the aftermath of World War II, it was abundantly clear that an international system was needed to hold perpetrators accountable for human rights violations. The Nuremberg trials, a series of 13 trials held between 1945 and 1949, where Nazi officials were convicted of war crimes, crimes against humanity, and crimes against peace, established that individuals may be held criminally responsible for international crimes, even where the particular individual may be head of state. Following this, the atrocities revealed during the Nuremberg trials inspired the adoption of the Universal Declaration of Human Rights, 1948, by the United Nations General Assembly. The Declaration outlined fundamental rights, set the foundation for global human rights standards and norms, influenced future human rights treaties, conventions, and international institutions, and sought to ensure that the crimes prosecuted at Nuremberg would not reoccur by promoting dignity, equality, and justice worldwide. All 193 member states of the United Nations have signed the Universal Declaration of Human Rights, with each state having ratified at least one of the 9 legally binding core international human rights treaties influenced by the Universal Declaration of Human Rights, with the vast majority of countries having ratified 4 or more. Other treaties have followed, such as the International Covenant on Civil and Political Rights and the Convention Against Torture, which bind signatory states to specific human rights obligations. The global human rights framework we recognise today has ensured that individuals' human rights are protected and upheld, whilst also incorporating judicial and monitoring mechanisms to ensure accountability where human rights violations occur. I will now turn my attention to my second argument, namely the judicial mechanisms and how they deliver justice. Following the judicial precedent set down in the Nuremberg trials, international judicial bodies have played a pivotal role in addressing severe human rights violations. Although the International Criminal Court does not prosecute states directly, its actions challenge state-sanctioned human rights abusers by targeting responsible individuals, prosecuting high-ranking officials and leaders, thereby holding the state accountable for policies or actions that led to human rights violations. Perhaps the most notable example of this would be the International Criminal Court issuing arrest warrants for Sudanese President Omar al-Bashir for genocide and war crimes in Darfur, signalling that state-sponsored atrocities would face global scrutiny. International criminal tribunals have also played a role in holding states accountable, prosecuting leaders responsible for atrocities during the Yugoslav War, convicting individuals involved in the Srebrenica genocide, and also prosecuting key figures involved in the 1994 Rwanda genocide. Regional courts have further been implemented and provide another mechanism for accountability. The European Court of Human Rights ruled against Turkey in a case for property rights violations in Cyprus, forcing compliance and reparations, whilst the Inter-American Court of Human Rights has held states accountable for forced disappearances and indigenous rights violations, as seen in the case of Velázquez Rodriguez and Honduras. The current human rights framework has developed a range of judicial mechanisms, creating both international and regional courts, international tribunals, whilst also giving the platform for domestic courts to hold key state figures and in turn states themselves accountable for human rights violations, as demonstrated through the examples above. Turning to my third argument, to look at the impact of monitoring and reporting mechanisms. The current human rights framework extends beyond judicial mechanisms, fostering monitoring mechanisms with human rights compliance being monitored by bodies such as the United Nations Human Rights Council and treaty-based committees which expose violations and demand corrective measures. For instance, the Universal Periodic Review subjects all United Nations members to scrutiny, fostering transparency and accountability. While special repertoires and committees, such as the Committee Against Torture, monitor compliance with international obligations and also bring attention to these violations. Monitoring and reporting create a detailed record of human rights abuses, which in some cases has later served as evidence in judicial processes. This was seen in the United Nations Independent International Fact-Finding Mission on Myanmar. Evidence was collected on the persecution of the Rohingya, which was later used in proceedings at the International Court of Justice and the International Criminal Court. Further, organisations such as Amnesty International and Human Rights Watch produced publicly accessible records which increase global awareness of ongoing violations. This awareness spurs international pressures, threatening and often leading to sanctions imposed, aid restrictions, or other measures to push states towards compliance. The mere existence of these monitoring bodies pressures states to improve their human rights records, illustrating their effectiveness in holding countries accountable, whilst also exposing and reporting violations to the judicial mechanisms set out previously. Turning to my fourth and final argument, the impact international law has on the influence international law has on global norms and state behaviour. International law's impact can be seen to shape states' behaviour through establishing global norms. The use of sanctions and diplomatic pressure can be seen imposed on states or international organisations, and this international condemnation can pressure states to amend policies and improve human rights practices where necessary. The international response to apartheid in South Africa, driven by the United Nations resolutions and sanctions, forged the regime to transition to democracy. Many states have now incorporated international human rights treaties into their domestic law. To reiterate my point from my first argument, 193 countries have incorporated at least one of the treaties into their domestic law. which in turn improves the general protection of human rights and increases accountability. Principles such as the prohibition of torture and genocide are now almost universally recognised, ensuring that human rights are protected even in non-signatory states, which in turn addresses concerns that the current system has little effect on non-signatory states. Even in cases where enforcement is incomplete, the reputational costs of being labelled a violator compels states to align their policies with international norms, proving the law's effectiveness through its mere existence. In conclusion, international law has proven to be an effective tool for holding countries accountable for human rights violations. Through binding frameworks, a history of successful judicial and monitoring mechanisms, and its influence on global norms, it creates a system of accountability that deters violations, delivers justice, and promotes human dignity. The progress achieved, although imperfect, is undeniable. For these reasons, I affirm the resolution and urge you to recognise the vital role international law plays in ensuring accountability for human rights abuses. Thank you.
Thank you, Robbie. We now welcome up Hannah to make the final submission for the dissenting side to the title.
Good evening all. The question before us is whether international law effectively holds countries accountable for human rights violations. I strongly argue that it does not. Despite its aspirations and many treaties globally signed, international law often lacks enforceability, suffers from political manipulation, and applies inconsistent standards, rendering it ineffective. I will use specific cases, including Israel, the US, and Russia, to reiterate Benjamin's point and challenge my oppositions. My first argument is its weak enforcement mechanisms. International law largely relies on voluntary compliance or external pressure for enforcement. Its mere presence does not infer effectiveness. For example, in Israel and Palestine, the International Court of Justice has issued rulings condemning Israel's actions in the occupied Palestinian territories, including practices amounting to apartheid and violations of international humanitarian law. Despite these rulings, Israel continues its blockade of Gaza and illegal settlements in the West Bank. The ICG's order for humanitarian aid access and an end to policies leading to potential genocides has been ignored. They have broken the Geneva Convention, which both Israel and Palestine signed, showing that just a signature is not effective. The Fourth Geneva Convention on Occupational Law has core prohibitions against collective and individual forceful transfers of a population within or from an occupied territory, which Israel has clearly done by bombing Palestine. The International Criminal Court is supposed to prevent crimes like genocide, which is clear in Israel, yet they have not managed to and costed many Palestinian lives. The ICC has never indicated a leader of a major world power, rather they mainly focus on African countries. This lack of enforcement is embellishment of international laws dependent on state cooperation. Without an effective policing mechanism, rulings become symbolic rather than actionable. If this international law was providing global norms, then North Korea would be more human rights. They have had many human rights concerns, such as no freedom of movement, harsh prison camps where whole families are punished where only one has made a mistake. They also have been accused of using the death penalty liberally, such as using public executions. International law has not successfully intervened, exemplifying how it does not hold countries effective for human rights violations. North Korea is also the only country to withdraw from the Nuclear Non-Proliferation Treaty. This authoritarian regime can seem threatening to other countries, so other countries are less likely to be inclined to intervene. In African countries, however, they have less political influence than great powers such as the US, and the ICC does seem to take action. For example, in 2021, 10 out of 14 of the investigations were in Africa. Considering the amount of violations happening in other countries, it seems that only when there is not a significant amount of power, the ICC can intervene and apply international law. My second argument is political bias and double standards. The application of international law is often selective and influenced by geopolitics. In Israel's case, Western nations, particularly the United States, have used their veto power in the United Nations Security Council to shield Israel from meaningful accountability. For last year, example, Biden supported Israel in their self-defense. This has blocked resolutions addressing human rights abuses, reinforcing double standards. Meanwhile, robust international measures such as sanctions are applied swiftly in other cases, like Russia and Ukraine. Furthermore, the US committed atrocities in Iraq and Afghanistan under Bush, yet they call Putin a war criminal for his actions in Ukraine. The US refused to take accountability for when they took over Abu Ghraib, as they photographed themselves abusing Iraqis. Biden has gone on record saying that Putin is a war criminal and evidence needs to be gathered for a war trial. This would be unlikely to happen because there had never been a trial of a figure as powerful as Putin, although they have launched an investigation into the crimes committed during Ukraine's war. This is a great double standard, and countries which international law is applied to, such as Russia, are unlikely to take the law seriously when the great powers, such as US, seem to escape the class of the international criminal courts. The ICC Rome Statute sets out the court's jurisdiction over genocide, crimes against humanity, and war crimes. In 2010, the text was amended to say, to please the United States and UK, that in respect of a state that is not party to the statute, the court shall not exercise its jurisdiction over the crime of aggression when committed by the state's nationals or its territory. Russia can formally utilize this to argue it is immune from ICC prosecution, as Ukraine is not an official member of the court. Similarly, in China, international law has failed to address the detention over 1 million Uyghurs in Xinjiang. UN experts and NGOs have documented widespread abuses, including forced labor, cultural erasure, but political and economic ties have prevented decisive international action. These inconsistencies undermine the credibility of international law, as it appears to prioritize political politics over international justice. For my third argument, I will be discussing lack of political will and accountability. Even when international bodies take action, political will to implement them is often lacking. For example, Israel and the EU. European nations, while vocal on issues such as Ukraine, has been criticized for failing to act decisively against Israel policies. Countries such as Germany and Hungary have blocked measures to hold Israel accountable, even when ignoring ICJ rulings. This reveals a lack of commitment to international law when political alliances are at stake. In conclusion, the ineffectiveness of international law lies in its structural limitations, politicized application, and lack of enforcement mechanisms. The cases of Israel, Myanmar, China, and Saudi Arabia illustrate a troubling reality. The cases are... For these reasons, I urge you to recognize that international law in its current form fails to hold countries accountable for human rights violations. Thank you.
Thank you. As briefly mentioned at the start, the debate now opens up into a direct cross-examination and rebuttal period. You can work out between you who is going to start.
Okay. So I think maybe it's important to establish some terminology. So effectiveness. You're essentially saying you concede that the rulings of, say, the International Court of Justice are not binding on member states. So my understanding of effectiveness would be that it achieves a intended outcome. So how can you call it effective simply if there is no guarantee that that will happen?
I would argue that there is a history of success from the rulings, although there are many current examples which action has not been taken in yet. Unfortunately, I think with international law, it is more of a case of post-action rather than action in the intermediate. Whereas, as seen with the Nazis at World War II, and as seen in the very big Rwanda genocide, there is more post-action taken, where the rulings and the pressure put on a state to change their ways and incorporate international law. There's more pressure after these events occur, unfortunately, given the mass scale of genocide and war going on. I would concede, yes, that unfortunately international law does not have enough bearings to act in that instance, and it is more of a post-action, which is when international law can show its effectiveness. So it's almost a different way of being effective in the post-action, and I would concede, yes, that more needs to be done in the instant action to target war generally. However, I would say that it has also been effective in other ways in terms of setting norms in terms of torture and genocide, but unfortunately there is still things going on that need to be targeted, and I hope to see that these, or I'm sure that this will be seen in the post-action stage, as unfortunately in the first instance enough isn't being done.
Thank you. I might push back a bit on use of the Nuremberg trials, given that the context in which those took place, the Allied forces operated Germany, and obviously divided among the four parties. And it was essentially, well, there was ground legislative action that was taken. This does not mirror the current situation. Unless you wanted to invade China, for example, you can't really hold them account for the reported cases of terrible human rights violations against the Uyghur population, for example. And I think I would. Sorry, do you have anything to input?
I don't have anything to add to that, but I've got a question for you. You say that human rights law is applied more retrospectively. The US violations happened in 2002, most of them in Iraq and Afghanistan, and they still haven't had any international implications from their actions, whereas loads of African countries have had human rights violations more recently, and there has been a lot of action there, such as 10 out of the 14 investigations being in Africa. How can you say that it's international law when it's more focused on one continent that it's effective in?
Well, of course, you've alluded to the fact that the veto powers, of course, exist. But however, I would argue in this instance with the veto powers that they more reflect the greater states' power and the geopolitical powers that they have as larger states. And because of the veto powers, it is, of course, more challenging to pass judgment or to investigate into these countries with the veto powers. However, I would also argue that institutions such as Amnesty International and other monitoring organisations continuously investigate into the USA, specifically with the 2020 and 2021 Black Lives Matter. Amnesty International has reported and made many investigations into police brutality and so on, and there are further examples since 2002 of organisations putting pressure onto countries such as the USA to change their ways. But unfortunately, because of the veto powers, the court, such as the ICC, hasn't been able to pass judgment against the USA in this case.
I would say that in order for it to be effective, more power needs to be given to each individual country rather than some countries holding all the power within international law. And so would you say that there is some bias in applying international law to countries?
I wouldn't necessarily say there's bias. I would say that it is a fact that some states have more political will simply because of the size of the state and the powers that come with them. But I would reject the notion that there is bias or any sort of favoritism in the way that the courts target or pass judgment or investigate.
Sorry, I recalled what I was going to say earlier. So you mentioned Amnesty International and the documentation of human rights violations, and that's all well and good. But surely that's a prerequisite to pursuing justice, that this information is fine on itself, but unless we actually do hold these countries to account, as in they incur a consequence or some sort of punitive consequence for their actions, then there's no real purpose in upholding the law. And that's, I think, what was illustrated, Hannah pointed out, in the instance of, say, Iraq. So you mentioned lack of political bias, but surely when we've illustrated through the veto powers that any resolution in the UN Security Council can just be vetoed. So nothing is going to be tabled as a motion. And secondly to that, the United States and the United Kingdom don't recognize the jurisdiction of the International Court of Justice's rulings. So even on a base level, there seems to be an inequality here between the more powerful nations and smaller nations. And so inconsistent application of precedent arguably is not justice.
The US is, I think, the most challenging country to establish international law in. There is precedent that rulings have been made against the UK, although, again, the veto powers do stand again. However, the pressure that's put on these countries, notwithstanding the veto power, and I think the veto powers simply play a big role in ensuring that these larger states maintain their interest in the UN and promoting human rights rather than acting unilaterally and disembarking from the UN altogether. I'd simply reiterate the point that aside from the judicial mechanisms, the pressure put on, and the reputational damage from being labelled as human rights violators, although not on the same footing as judgment being passed or a ruling against that particular country, does have an effect on states.
I can see that point, but I think you're presuming that a recognition of a violation of human rights in of itself carries significance when it comes to how countries operate. Often countries act in their own self-interest. We've seen that in the case of Russia recently in the invasion of Ukraine, Israel, Palestine. The International Court of Justice issued a ruling against Israel. Israel has chosen to ignore it because it's just a judicial opinion. And so I would query, sorry, could you reiterate your point, sorry?
Yes, so it is not only the rulings that the rulings more firmly put sanctions onto a state, but it's also the pressure and the reputational damage to a state as a state from being known as a human rights violator, and the organizations that exist that put pressure on these countries to change their ways and to recognize human rights norms and standards also has a bearing on, also has a degree of teeth in enforcement. Sorry.
Many countries won't care about their reputation, and this will not affect how they act. For example, North Korea has been labelled as an awful country, many human rights violations, which is a known presumed fact by many, and this would not stop them in any way. Same as Russia, which Benjamin mentioned. And also with political bias again, Hungary, Germany and the US all blocked because of their political ties to Israel, such as the fact that they sell many weapons to them, the US. And this arguably shows that there is some bias, as they're only blocking this not because of their beliefs that they haven't committed a human rights violation, it's because of their political ties to them.
I'd like to reiterate the point in terms of the current difficulties with Palestine, as you've mentioned, and also in the case of Ukraine at the moment, the post-action that I previously alluded to. I think that in these sort of current cases, you need time. We need to see what action is taken following these. I would like to bring it back to the Rwanda genocide that I believe you did allude to in your opening speech. The UN was failed to act in the instance, I'll concede that, in the Rwanda genocide. However, following that, 93 individuals were indicted by the International Criminal Tribunal for Rwanda that was set up following that, including some government ministers and military leaders, and a precedent was set following that. One of the individuals indicted, Jean-Paul Akiesi, was the first person convicted of genocide and the first person to be convicted of using rape as a weapon of genocide. And I think, I like to hope that following these current examples that are ongoing, and again, the pressure and the media attraction brought to these instances will give an opportunity for more to be done, and reform in areas of the system to give it more teeth in that way of acting in the first instance and judgments. Also, given that there are a number of examples of lesser states, if I put it that way, being having judgments against them. However, as you've alluded to, and I do concede, there is difficulty with the larger states, such as the USA. There is difficulty with the bearings on these larger states. However, there is precedent, or there is a history of successful cases against lesser states, again, to put it that way. Yeah.
Well, I think that kind of underscores the point that international law itself may not be affected, but rather the political, geopolitical views and intentions of nations pressuring other countries within their interest and using the UN Declaration or international law, cherry picking when to utilize it, rather than all nations unanimously striving to uphold the standard, is exactly the issue, because it's a weaponization of a treaty. And I think that that's, well, clearly illustrated in the sense that China, Saudi Arabia, well, clearly the West does not side with China. There's a lot of tension between those two nations. China continues consistently, we've already mentioned, I won't reiterate the point too much, to commit human rights abuses. And the West will continue trading with Saudi Arabia, I think, and they will, for example, in Syria, I think I mentioned the Saudi Arabian regime's actions in Syria. The West have never brought any claims against them because they are a strategic ally which is against Iran, and Iran is allied with Russia and China. And so it's almost a game of ping pong. I think that states turn to use international law when it suits them and their interests. And that again re-emphasizes the point that it is a tool for already the geopolitically influential, rather than as a tool for arguably the lesser states. From a structural level, the fact that 5 members of the European Security Council have permanent residency, and there's an alternating other 10, as you know, over the 15. Surely that is just unfair from that level. They have almost a dominance on the narrative. And also there's a stalemate, because as China and Russia are allied, so are France, the UK, and the USA. And so it's so ineffective in that regard. And again, I would come back to your illustration of norms being established. I would query that, because the fundamental issue from the outset, I will agree that it's an ambitious project, the United Nations, because you're dealing with a vast array of countries, different historical backgrounds, different views, trying to galvanize them to subscribe to a brand new doctrine. But that in of itself, I would say, is the point in that Afghanistan, totally different cultural values. The Taliban, as I'm sure you're aware, increasing legislation, women are no longer allowed to speak in open spaces. These norms, if there were any, which I would question, have definitely eroded. And it's more that the historical, and I will wrap it up here, the historical bias and influence of the West for the longest period of time that has pressured these countries, developing nations for the most part, because if you were to apply the modern day human rights doctrine against our history, we know we'd fall short. And it's weaponizing that tool essentially on these countries. I don't see that as just.
In terms of the cultural difference that you alluded to, would I be right in saying that you are of the position or of the opinion that human rights has been more influenced by the West. Is that correct to say in the final part that you said?
No, it's definitely amalgamated from a collaboration of both Western and Soviet influence, no doubt about that. The linchpin of my argument was more Western economic domination. I should have maybe illustrated that better. Geopolitical influence of the West, and I should really say, yes, Russia and China, the larger nations. And yes.
We do there. So in 1990, there was the Cairo Declaration on Human Rights in Islam, which reflects an effort by some Muslim majority countries to reinterpret human rights within the framework of Sharia law. So we do see efforts to bridge the gap in cultures and to, rather than have it almost westernized, or to have a large effect from the West, we do see attempts at trying to interpret other cultures and other regions or areas into human rights. Yeah.
We are at the natural end of this time, so your response will need to find the natural end of the debate.
I would say that the question is not whether they have made efforts, it is whether it is effective or not. And people such as the Taliban have been increasing their human rights violations rather than stopping it. And I would say this shows that human rights law internationally is not effective in holding countries accountable for this, as it is not stopping, it is a growing issue. And this shows that it's simply not effective.
Thank you, everyone. We now welcome the audience members and the speakers, if they wish, to vote for who they believe best argued for and defended their side of the title. The votes are in, and by an absolute majority, the dissenting side successfully argued the title of this second Thomas More Club debate. A round of applause.